Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 17, we're continuing our in-depth exploration of Part 2, Public Records, specifically see what records are covered. Application of the Public Records, Act 2. We'll be navigating pages 139 through 148 of your manual. Our discussion will continue our deep dive into personnel records, Section 18, specifically covering complaints against public school and state university college system employees, conditions for inspection, criminal history, deferred compensation, drug test results, employee assistance programs, employment search records, performance evaluations, examination questions, and the extensive list of personal information covered by exemptions for various public officers and employees, taking us up to impaired practitioner consultants. Given the extensive detail, this episode will be significantly longer than our usual 15 minutes. Let's pick up right where we left off with personnel records, looking at complaints against employees beyond law enforcement. Segment 1, C, what records are covered? Personnel records, complaints against employees, public school and state university and college system, pages 139 to 140. In our last episode, episode 16, we discussed complaints against law enforcement and correctional officers. Now, continuing on page 139, under D, there's complaints against employees, 18.d, we'll cover other types of public employees. First, we have 2, public school system employees, 18.2, on page 139. Records related to complaints and investigations of misconduct against public school employees, like teachers, administrators, or staff, also have specific confidentiality rules. Typically, information identifying the employee and details of the complaint are confidential during an active investigation. This protects the employee's reputation during an unproven accusation and the integrity of the school district's investigative process. Once the investigation is concluded and any disciplinary action is finalized, much of this information generally becomes public, but still with an eye toward protecting privacy for non-relevant personal details. Next on page 140, we look at 3 state university and Florida college system institution employees, 18.3. Similar to public school employees, records concerning complaints and investigations of misconduct against employees of state universities and Florida college system institutions also have periods of confidentiality during active investigation. The same principles apply. Protecting the employee's privacy during an unproven accusation and safeguarding the investigative process. Once a final agency action is taken or the investigation is complete, the records often become public, subject to redaction for confidential information. Segment 2, C, what records are covered? Personnel, records, conditions for inspection, criminal history, and deferred comp, pages 140 to 141. Continuing on page 140, we move to E, conditions for inspection of personnel records, 18.E. This section clarifies that while many personnel records are public, there can be reasonable conditions placed on their inspection and certain privacy considerations apply. 1. Privacy issues, 18.1, on page 140. Even for public personnel records, agencies must protect an employee's privacy regarding information that is not related to their official duties or public accountability, and this might include personal medical information, family details not relevant to employment, or social security numbers, which are generally confidential in all public records. Agencies are responsible for redacting or withholding such purely private information from public portions of personnel files. 2. Sealed records, 18.E.2, on page 140. Just like in criminal history, some personnel records may be sealed by court order. If a record related to an employee's past is sealed, agencies cannot disclose it. This is typically rare, but can occur for very specific legal reasons, such as a prior juvenile offense that has been expunged. Next, on page 141, we discuss F, criminal history information, 18.F. For public employees, criminal history information used during hiring or maintained during employment is a complex area. While an employee's convictions for offenses that relate to their job duties might be public, more detailed criminal history records, like arrest records without convictions, are often confidential and only accessible to specific government entities for background checks or official purposes. The balance here is between public safety and an individual's privacy in their employment context. Also on page 141, we cover G, deferred compensation, 18G. This refers to records related to an employee's participation in deferred compensation plans, which are retirement savings programs where a portion of an employee's salary is set aside for payment at a later date. These records are generally considered confidential and exempt from public disclosure to protect the employee's personal financial privacy. They involve individual investment choices similar to annuity records. Segment 3, C, what records are covered? Personnel. Records direct deposit, drug test, employee assistance, and employment search, pages 141 to 142. Let's continue on page 141 with more personnel record types. First, hour. Direct deposit, 18.H, on page 141. Records that contain an employee's bank account numbers or routing information for direct deposit are universally confidential and exempt from public disclosure. This is a crucial privacy protection to prevent identity theft and financial fraud. While payroll amounts are public, how the money gets into an employee's account is highly protected. Next, drug test results, 18.1, also on page 141. Records containing the results of drug or alcohol tests performed on public employees are generally confidential and exempt. This protects employee medical privacy. Disclosure is usually limited to the employee themselves, their union representatives, or certain management personnel for employment-related decisions. Moving to page 142, we find J, Employee Assistance Program, 18.J. Employee assistance programs, often called EAPS, offer confidential counseling and support services to employees dealing with personal or work-related problems. Records related to an employee's participation in an EAP and any information shared within it are considered highly confidential and exempt. This confidentiality encourages employees to seek help without fear of their personal issues becoming public knowledge, which is vital for the program's effectiveness. Also on page 142, we cover K, employment search or consultant records, 18K. These are records related to the process of finding and hiring new employees, especially for high-level positions when an agency uses a search firm or consultant. Information related to unselected applicants or the confidential deliberations of search committees or consultants may be exempt during the active search process to protect privacy and attract a broad applicant pool. However, once a decision is made and a person is hired, information about the successful candidate and finalists often becomes public, as we mentioned earlier regarding applications. Segment 4, C, what records are covered? Personnel records, employee performance evaluations, pages 142 to 143. Now let's turn to page 142 to discuss L, evaluations of employee performance, 18.1. This is a significant area with specific confidentiality rules. Generally, performance evaluations of public employees are confidential or exempt from public disclosure. The rationale is that confidentiality encourages candid assessments by supervisors and honest self-reflection by employees, which can lead to better performance. Making them public might lead to generic, less useful evaluations. Let's look at some specific contexts. 1. Hospital employees, 18.11, on page 142. For employees of public hospitals, their performance evaluations are typically confidential and exempt. This aligns with the overall privacy protections often extended to medical facilities and their staff. 2. Public school employees, 18.L2, on page 143. Performance evaluations of public school employees, including teachers and administrators, are also generally confidential and exempt. This helps to facilitate honest feedback for professional development without fear of public scrutiny. 3. State University and Florida College System Institution employees, 18.1.3, on page 143. Similarly, evaluations of employees within the state university system and Florida College System institutions are also typically confidential and exempt. The same logic applies, promoting frank assessment and professional growth. It's important to note that while the evaluations themselves are often confidential, general information about an employee's employment, such as their salary, job title, and dates of employment, typically remains public. The exemption is very specific to the subjective content of the performance evaluation. Segment 5, C. What records are covered? Personnel records, examination questions and personal information, Part 1, listing intro, page 144. Moving to page 144, we cover two more crucial aspects of personnel records. First, MSHA examination questions and answer sheets, 18.M. These refer to the actual questions and answer keys used for employment examinations or professional licensing exams administered by public agencies. These are generally confidential and exempt from public disclosure. The reason is obvious. If these were public, the integrity and validity of the examinations would be destroyed. They could be memorized, undermining the fairness and effectiveness of testing for qualifications or job suitability. This exemption ensures a level playing field for all applicants and maintains the quality of public hiring processes. Next, on page 144, we begin a very extensive and highly important section. N. Home addresses, telephone numbers, and other personal information, 18.N. This is a critical area of privacy protection for certain public officers and employees. The law recognizes that due to their public service, some individuals may face risks of harassment, intimidation, or even threats if their personal identifying information were widely available. The manual begins by providing a listing of public officers and employees covered by exemptions, 18.1, on page 144. This is a long list of specific positions or types of employees whose home addresses, telephone numbers, social security numbers, and other sensitive personal identifying information are made confidential and exempt from public disclosure by specific statute. It's not a blanket exemption for all public employees, but rather for those identified as having a heightened security or privacy need due to the nature of their work. This list is incredibly detailed and is updated periodically by the legislature. We will go through the first part of this extensive list in this segment. The specific categories mentioned on page 145 through 148 are AEE abuse investigators, 18.1A, on page 145. This protects individuals who investigate child abuse, vulnerable adult abuse, or other types of abuse, often putting them in sensitive situations where their personal information could be targeted. B, Child Advocacy Centers and Child Protection Team, 18.1.1b, also on page 145. Personnel working in these crucial child protection roles have their personal identifying information shielded for similar safety reasons. C, Clerks of the Circuit Court, 18.11c, also on page 145. The personal information of these important local government officials and their staff is also protected, likely due to the sensitive nature of court records and their public-facing roles. D, Code Enforcement Officers, 18.1-1-D, also on page 145. These officers often deal with contentious issues with property owners, and their personal information is protected to prevent harassment. E, County Addiction Treatment Facility Personnel, 18.11e, on page 146. This protects staff working with vulnerable populations in addiction treatment facilities. F, County and City Attorneys, 18.11F, on page 146. Lawyers representing public agencies often deal with controversial issues, making their personal information a target for harassment. G. County tax collectors, 18.1G, on page 146. And these officials handle sensitive financial data and are often the subject of public scrutiny, hence the protection of their personal details. H. Domestic violence advocates, 18.11H, on page 146. These individuals work directly with victims in highly sensitive situations, requiring their personal safety to be protected. I. Domestic violence and specified other crime victims, 18.11I, on page 146. This reiterates and specifically lists victims of domestic violence and other specified crimes as having their personal information protected, reinforcing Marsy's law and other victim protections. J. Emergency medical technicians or paramedics, 18.11J, on page 147. These first responders often work in emergency situations where their personal information needs to be secure. K. Firefighters, 18.1K, on page 147. Similar to other first responders, firefighters' personal information is protected for safety and privacy. L. Gaming Control Commissioners, 18.111, on page 147. Those involved in regulating the gaming industry may face heightened risks, justifying personal information protection, and Millie Guardians ad litem, 18.11 NIM, on page 147. As we mentioned in episode 11, those who represent the best interests of children in legal proceedings have their personal information protected due to the sensitive nature of their work. Numero hospital employees, 18.11.1, on page 147. This protects the personal information of employees working in public hospitals, similar to other health-related confidentiality. OO Human Resources Managers, local governments, 18.110, on page 147. These individuals handle sensitive employee information, making their own personal data vulnerable. P. Impaired Practitioner Consultants, 18.1P, on page 148. These consultants work with licensed professionals who may be dealing with impairment issues, a sensitive area requiring confidentiality. Quarter Inspectors General and Internal Audit Personnel, 18.1Q, on page 148. These individuals investigate potential misconduct or inefficiencies within agencies which can make them targets for retaliation or harassment. This lengthy but crucial list demonstrates the legislature's careful approach to balancing transparency with the genuine safety and privacy concerns of public servants. This concludes our detailed exploration of the initial categories of personnel records under C. What records are covered, taking us through page 148 of your manual. Thanks for listening. In our next episode, episode 18, we'll continue our deep dive into personnel records, specifically covering the remainder of section 18.N.1, along with other personnel categories like medical information, payroll, and security system information, taking us through page 163 of your manual. Until next time, remember the truth dies in the dark, so let's leave the light on